Hello, here we have Tara Sease and Morgan Bonekovic talking about family law in Allegheny County. We're going to start with Tara. Tara, what is child custody?
Hello. Child custody refers to who has the care and control of a child or the children. For child custody, there is legal custody, and this is the person who makes the major decisions about the child's education, health, religion, those types of decisions. Within legal custody, there's either sole legal custody, which is when one person has custody, or shared legal custody, which is more than one person. And generally in Allegheny County, Pennsylvania, when there are two living involved biological parents, the default is shared legal custody. In addition to legal custody, there's physical custody. This is who the child is physically with. Think of who the child is spending overnights with. And there are a couple types of physical custody. There's sole physical custody, which is when only one person has custody. There's shared physical custody, which is when two or more people share somewhat equal time with the child. There's primary physical custody, which is when someone spends more than 50% of time with the child. And then there's partial custody, which is less than 50% of the time. The last is supervised custody, and this is any duration of time that is spent with the child, but the person who is exercising custody has to be supervised by another person or by the court.
Why is it important to have a court order?
I think that it is very important to have a custody order in almost any occurrence because there's a fallback, there's a default. This happens when parties can't agree, when the schedule changes, the event that a parent is unavailable, detained, deported. A child may be left behind in the care of a family member, another caregiver, one of the parties. When you have a court order in place, this shows and tells other people how the custody is. Without an order, the caregiver or the custodial person may not be able to provide proper care for the child, may not be able to consent to medical care, make educational decisions, may not be able to obtain a passport, may not be able to travel with the child from different counties, states, or even outside of the United States. It's also important to know that a custody order may be in place even if the child is not a U.S. citizen or has some type of dual citizenship.
Who has custody rights if there is no custody order?
So here in Pennsylvania, if there's no custody order in place, both parties, who are the parents, have equal rights to the child. This is important to remember because even if the biological father's name is not on a child's birth certificate, that person still has the same equal rights to the child. Also, in some scenarios where the paternity of the father is in question and there is no name on the father's name is not on the birth certificate, then the father may have to acknowledge paternity. But even if the father is not named on the birth certificate, the person who is filing or seeking custody must name both parents. They also must name, they must serve both parents so that everybody's given the chance to participate.
Who can file for custody of a child?
So in Pennsylvania, the general rule is that only biological parents have the right to file for custody of a child. And there are some specific scenarios called grandparents' rights, where grandparents have the right to seek partial or primary custody under certain circumstances. All other parties, meaning third parties, do not have the right to file unless they can show one or two scenarios. The first scenario is that they can show that they stand in loco parentis to the child. And that means that they have assumed the right and the role of the parent with the parent's consent of that child. This is very specific in our courts. The courts have to decide this based on all the facts of each specific case. The other time is whenever neither parent has care or control of the child and the person seeking custody can show that they have a genuine concern for the child and established relationship with the child.
Now we'll move to Morgan, and she's going to talk about parent and child separation. Morgan, can I still file for custody if another parent does not live in Pennsylvania?
So as a general rule, a parent can still file for custody in Pennsylvania if it is considered the child's home state. And the child's home state is going to be where they've resided for at least the past 6 months, the state and the county. And that is still in effect, even if the other parent lives somewhere else, whether it's a different state or outside of the United States. There can be exceptions depending on your family situation. There are cases where maybe nobody's lived anywhere for 6 months. So it's important that you consult a family law attorney to determine if Pennsylvania, and specifically the county that you're in, is the correct county to file in. When you do file a custody complaint, and you do have to serve it on the other party that is outside of Pennsylvania, it needs to include all of the information that you know about that person. So you need the address, you need the names of all of the biological parents, and you have to take every effort that you can to ensure that the other parent is served. They have to be served with the custody complaint. They have to be served with any notices or petitions for upcoming hearings or conferences. So if you do run into a situation where you don't know a parent's address, or perhaps you don't even know the parent's full name or identity to be able to track down their address, you do have to ask the court then for permission to serve them in a different way, whether that be by publication or something else. There also may be a situation where the other parent resides somewhere where service isn't possible. So maybe they don't receive mail service where they're living. If that is the situation, then you do have to, again, provide the court with that information and ask them to permit you to serve them in another manner.
What happens when a parent becomes unavailable?
So in the event that one parent becomes available, if you do have a custody order in place, then you are protected. Your rights to the child or children have been established, and you can operate as if you are the only parent at that time. What becomes more difficult is if both parents become unavailable for whatever reason. So if no one is available to care for the child, they will likely be placed with your local child welfare agency. In Allegheny County, that's Children, Youth, and Families, or what you would hear referred to as CYF. There would be a dependency petition filed asking somebody to take emergency temporary custody of the children. Allegheny County does have specific services to assist families that find themselves in that situation. Potentially, you could have a placement with a family member. If there's not a family member, though, the CYF will determine where your children will be placed. So if your children are placed with not a family member, it could be in a group home or a residential treatment facility, or with some other sort of foster care. After the dependency petition is filed, there will be a court hearing, and all parents involved in that will have an attorney appointed to them, or they do at least have the right to an attorney. A parent's ability to regain custody of a child after the dependency petition has been filed can be limited, especially if the parent is detained or deported. It is very important that parents seek the advice of a lawyer right away if children are placed in the custody of CYF.
If a parent is worried about their immigration status, what steps should they take to protect their children?
So in the event that a parent is detained or deported, they may want a family member or a friend to care for the children if they're available. I would caution everyone not to simply go to a notary and have an agreement of this sort signed, because that form is probably not going to be accepted by schools or doctors. It's not a custody order, and therefore it's not enforceable by court. However, if you do have an agreement like that in place, it can be used as evidence to show what you intended as a parent and what you wish to have happen for your children should you be detained or deported. If you are able to get a custody order in place before that, the person caring for the child then would be able to obtain public benefits for the child, including food stamps. So this option does allow a non-parent family member or caregiver to have the authority to make decisions on a temporary emergency basis without actually being granted custody and having to go through the court. It could be used, again, as evidence of the parent's wishes for the caregiver. However, if you do only have the notarized document, the caregiver does not have a custody order and therefore might not be permitted by the school or the medical caregivers to provide any information on the child, and it's not enforceable in court. So that option could also potentially, though, grant the third-party person, whether that be a family member or a friend, in loco parentis status, which was discussed by Tara a little bit earlier. So it may show evidence that that person has been standing in place of a parent and it was done with the consent of the biological parent.
What would the child need to travel internationally?
So in order to travel outside of the United States with a child, the child needs to have a passport, and many airlines do require that both parents be there. So in scenarios where we have two people that are co-parenting and going on separate vacations or travel plans, it's always helpful to travel with your court order and or a letter stating that they have authorized the parent to take this child out of the country. For a passport application also, when there are two parents and they have shared legal custody, this is a shared legal custody topic. So that means the requirement is for either both of them to sign the application, or there's a process where if one parent is in agreement with the child having a passport, but for some reason can't be present for the application or interview process, they can sign some type of documentation to authorize the passport to be produced. Now, if you have sole legal custody, which is the sole decision-making power of the child, that individual can apply and essentially get a passport for the child without the involvement of the other parent.
What would a parent need to do if they would want to relocate?
So in cases of relocation, whether it's outside of the current county or the state or internationally, our courts have two ways that the parties can relocate. Again, I would advise everybody to speak with a family lawyer in that specific area where my colleague talked about the child's home state or home county, the proper place to file this action prior to relocating. But the courts essentially say that there are only two ways a parent can relocate. One, by consent of both parties. So both parties agree that one of the parents or custodians is going to move out of county, state, or country, and there's an agreement. Or you have to go through the courts and get a court order approving the relocation. And in different counties and states, there are processes that you have to go through to get that court order, which also take time because a judge has to go through an evidentiary hearing to either approve or not approve the relocation. And then if the relocation is going to conflict with the current or affect the current custody order or arrangement, then there's going to have to be another deciding of custody and what that custody schedule is going to look like. Another topic of discussion with relocation is whether you are planning on relocating by yourself or with the child. And in family law, it is very specific when the child's schedule is going to be disrupted. So even if there's not an underlying custody action and there has never been anything in custody court, it is very important to understand that you should most definitely file a relocation prior to leaving and following that specific procedure and essentially initiating the litigation, because without it, the judge or the trier of fact may order you to return and or the child to return based on some lack of why you should or were not permitted to relocate.
Now that we've talked about custody, let's talk about protection from abuse orders. What is a protection from abuse order?
So a protection from abuse order is a court order which is meant to restrain the actions of an individual. So a PFA order can stop someone from contacting you, it can stop someone from visiting you at work, it can evict them from the residence you're living in, and it can also provide those same protections for your children if they are covered in the protection from abuse order.
What are the different types of protection from abuse orders?
So there are essentially two types of protection from abuse orders in Pennsylvania. You can have a temporary protection from abuse order, or you can have a final protection from abuse order. Under the realm of temporary PFA orders, there is an emergency order and a temporary order. So the difference is an emergency order is obtained generally after hours, after court hours, and you would have to go to your local magistrate or to a magistrate judge downtown. You would tell them the facts that you are pleading to obtain your PFA, and it is granted only for 24 hours. So the next day, you would be required to go to the courthouse, the family courthouse downtown, and at that point, you would sort of go through the same process, provide them with the facts that you will be putting into the pleading, asking for a protection from abuse order. That temporary order, if granted by the judge, then lasts up until the hearing for the final protection from abuse order. That hearing is generally scheduled within about 10 days. So then the final protection from abuse order is the order that would be granted to you after an evidentiary hearing.
Can you tell us more about the process to obtain a final protection from abuse order?
So in Allegheny County, to obtain a final protection from abuse order, you'll be scheduled to go to the courthouse at 9 a.m. on a specific day. Everyone that could potentially have a PFA hearing that day will all arrive at 9 a.m. At that time, there is an opportunity for your attorney. You will be appointed an attorney free of charge. That attorney will speak to either the defendant who you are filing the PFA against or the defendant's attorney. At that point, they'll try to work out either a consent order or a civil order that will offer you similar protections as a final PFA order from the judge. If you're unable to reach a consent agreement, then you will have an evidentiary hearing before the judge. At the evidentiary hearing, you will be permitted the opportunity to provide evidence of the abuse that you're alleging. You can enter in photos and text messages, and you will testify. The defendant also has the opportunity to enter in their evidence and testify about the incident that occurred. So in order to win a PFA hearing and be granted an order, you do have to prove by a preponderance of the evidence that some type of either domestic abuse or sexual violence occurred. At the end of the hearing, the judge will decide if you have met your burden and if a PFA is necessary and should be awarded to you. If it is awarded to you, it can be in place for up to 3 years. Some of the protections that can be included in a final PFA order include having the defendant not harass you, stalk you, or communicate with you at all. You can be awarded temporary custody. You can be awarded exclusive possession of where you're living. So if you were both living together, the defendant would not be permitted to return to that house.
Why would someone want to get a protection from abuse order?
So in order to qualify to obtain a protection from abuse order, you need to, in the pleadings of the petition, say that you did experience some sort of physical abuse. You can also have experienced sexual abuse. There could also be the threat of physical abuse, and that threat put you in reasonable fear that you would be harmed, or if there was some sort of false imprisonment by the other party.
Can anyone get a PFA?
So you can't file a PFA against just anybody. Only those individuals who have an intimate or family relationship with an individual can file a PFA against that person. Some of the relationships that would qualify include current or former spouses, current or former sexual partners, current or former boyfriend or girlfriend, blood relatives that live in the same residence as you, relatives by marriage that live in the same residence as you, parents against children, and then also if you are in a same-sex couple relationship.
What happens if someone violates a protection from abuse order?
So once a final protection from abuse order is entered, that is a civil court order. However, if there is a violation of that order, the violation can be considered a criminal matter. So if you do call the police and allege that somebody is violating the PFA order, that person can be arrested. If they are arrested, then they will be charged with indirect criminal contempt. They can also be charged with that if they are not arrested. There will be a hearing scheduled where your interests will be represented by a district attorney, and the defendant could face fines, extension of the PFA order, and imprisonment.
All right, finally, we're going to talk about support. What is child support?
So child support is money for the child, and it is paid by the higher earning party and or the non-custodial party to the other parent to provide food, shelter, and clothing for the children. Child support payments also can include monies for the child's medical, for childcare, and schooling or tuition.
How is child support determined?
So here in Pennsylvania, we have established child support guidelines that will calculate the child support amounts as to what the obligor, the paying party, owes the obligee. And things that are taken into consideration are each party's monthly net incomes. And when you think of monthly net income for support purposes, that is income from whatever source derived. They also will take into consideration the number of children that each party has and the children of this matter. And then again, the custodial arrangement or overnights that each party has with the child.
What if the other parent is not paying their court-ordered child support?
In scenarios where a payor or obligor is not paying their child support, I would advise to speak with an attorney right away and either have the attorney or yourself file a contempt action and bring that matter to court. At that time, when the contempt is being argued and your case is being pled, the courts have remedies that they can enforce other fees, sanctions, and you can actually be sent to jail for not paying your court-ordered child support in Pennsylvania.
Am I allowed to withhold custody if the other parent is not paying child support?
So withholding custody is not a remedy for people not paying their child support. A custody order that we talked about earlier and a support order can be in effect, and most of the times are in effect, simultaneously. Again, the recommendation would be do not withhold custody, but seek contempt remedies through the court.